13A District Court for County Washington, State of Michigan is now back in session. The Honorable Judge Simpson presiding.
May be seated.
This case opens quietly, but don't let that fool you. What you're about to watch is a slow burn confrontation that explodes into a life or death standoff in the middle of a residential complex. Two men, one shared past, a woman in the middle, and a moment where a firearm turns a bitter dispute into a felony-level crisis. On one side, a resident who claims his life was threatened at gunpoint. On the other, a disabled man who insists he was defending his marriage and his home. The courtroom will now decide whether this was a criminal assault or a desperate act fueled by months of tension, jealousy, and unresolved money. Listen closely to how the story unfolds. The prosecution paints a sudden ambush. A gun under the throat, a barrel to the forehead, words that freeze the blood. The defense will try to reframe it as a confrontation provoked by repeated harassment of a wife over money that may never have been owed at all. This is not just about what happened in those 6 seconds with a gun. It's about what happened in the months before. Relationships, boundaries crossed, accusations, threats, and now, consequences. Who pushed first? Who escalated? And when does fear turn into a felony?
Court does call the case People versus Bruce Larkins.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender. What I can do.
Judge, I would ask that the officer in charge, Martez Gibbs, be allowed to sit with me at the counsel table, and we are going to sequester the other witness.
All right. Our witnesses are ordered sequestered. Defendant and officer in charge may remain. You call your first witness.
Thank you. We call Arnold Warnock.
Sir, please come forward and be sworn.
I swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. See, date and spell your first and last name.
Arnold Gornell, ARNOLD,
You may inquire.
Thank you. Arnold, is there something that happened on July 3rd of this year that brings you to court today?
Yes,
What was that?
sir.
Okay. And did that happen? Where did that happen?
Complex where I live at.
Where is that? Where's that located? Then, okay. And is that in the city of Ypsilanti, Michigan? Is that in Washtenaw County, Michigan? All right. So what happened when your life got threatened? How was your life threatened?
Well, I just come back from picking up deals from the Hope Center to bring back to the complex. Two for myself, along with my girlfriend, and 2 inbound people. I bring 2 for the last 7, 8 years. Then I pulled in the third handicap parking spot. I went back door and got the groceries out of the back because I turned around and started walking about 30 feet to the entrance to the building. This resident walked up to me and started mumbling something. I said, "What'd you say?" Says, "I told you never to speak to my wife again." I'm gonna lose my fucking brains out. Stepped back, jerked his shirt up, pulled a semi-automatic out of his waistband, shoved it under my throat for about 5, 6 seconds, kept saying the same word over and over. Removed it from there and put the barrel on my forehead for another 5, 6 seconds. Well, I figured I'm just dead man, so I just kind of took my arm up like that.
That sentence lands like a hammer. I just dead man. In plain language, the witness is telling the court that in that moment, he believed he was about to die. And in criminal law, that perception matters. Assault with a firearm doesn't require a trigger pull. It requires the credible threat of deadly force. A gun under the throat, a barrel on the forehead, repeated verbal threats. Those elements combine into what the law calls imminent fear of death or great bodily harm. Notice how he describes the timing. 5 or 6 seconds under the chin, then 5 or 6 on the forehead. That's not a flash. That's sustained dominance. It gives the prosecution a narrative of control, of intentional terror. But here's the strategic tension. This is still a one-on-one encounter. No video, no neutral witness. The entire case pivots on credibility. Was this a sudden ambush or a heated confrontation where both men were escalating?
Started walking away towards the entrance to the building, and he poked me in the back with it about 3 times.
Now, you just made a gesture about what you did with your arm. Can you describe what that was?
I said, I think I took my arm after he removed the gun from my forehead. I think it went like that, maybe against it, I don't know.
Okay.
Just a turn, it was my back would be coming.
All right. Is the person who did this to you in the courtroom today? Can you point him out and describe him, please?
Sitting right over there in white shirt.
Act to the record reflect in-court identification of the defendant, Bruce Larkins.
Without objection, record shall reflect.
Arnold, I'm going to show you what I've marked as people's proposed exhibit number 1.
Yeah, that's a 9mm semi-automatic.
Okay. All right. And do you recognize, is that the firearm he used that day?
Yes.
Okay. We move people's proposed 1.
Any objection or what here?
No, thank you.
Exhibit 1 is admitted, and yes, you may approach.
Oh, sorry. Thank you.
Yeah, I know you didn't ask. All right.
That's all I have. Thank you.
Thank you. Cross-examination.
Yes, thank you.
This is the courtroom's point of no return. When a witness points across the room and names the defendant, the case becomes personal. It's no longer abstract. It's no longer someone. It's him. From a legal standpoint, this locks in identity. The prosecution has now connected the story to a body in a chair. From a psychological standpoint, it sharpens the stakes for everyone watching, including the judge. The narrative now has a face. But watch what comes next. The firearm is introduced. Evidence transforms memory into material fact. A photo of the gun anchors the story in reality. This isn't hypothetical fear. This is steel and polymer. This is a loaded weapon recovered by police. Defense strategy will shift immediately after this. They cannot deny a gun exists. They cannot deny the defendant owns it. So the fight becomes context. Why was it displayed? Who provoked whom? Was this a threat or a warning? And here's the deeper layer. The defense will soon argue imbalance. A man with a cane, oxygen equipment, limited mobility, against a man who walks freely. That framing is coming. So the question forms, was this a predator's threat or a cornered husband's eruption?
Good morning, Mr. Gornell. It's my understanding that you and Mr. Larkins have resided in the same apartment complex for about 4 years. Is that correct?
I've been there 10 years. He's only been there 2 years.
So you believe he's only been there 2 years?
Pardon?
You believe he's only been there 2 years?
I believe so, 2021.
And would I be correct in stating that that is when you began to know him to have a relationship with Patricia, who lives in that building? Now, you stated that you pulled up to the complex and parked in a handicap space. Is that right?
Yeah.
And would I be correct in stating that the vehicle that you pulled up in has a handicap sticker or a handicap license plate?
License plate.
And that handicap license, that vehicle belongs to your girlfriend, Paula Mahler, is that correct? And that's her handicap license plate?
Yes.
Now, about the time you came to know Mr. Larkins through Patricia Larkins, pardon me, through Patricia, would I be correct in stating that you and Patricia had a romantic relationship?
Sexual relationship. I had a girlfriend and she had a boyfriend. We just weren't getting what we wanted from each one.
And would I be correct in stating that your girlfriend was Miss Mahler, Paula Mahler?
Yes, it was.
And if not in 221, at some point within these past 2 years, between 2021 and now, Miss Patricia married Mr. Larkins. Is that correct?
I believe she told me she got married in December of 2020.
Now, would I be correct in stating that you and Miss Patricia Larkins, Mrs. Patricia Larkins, sexual relationship, as you described it, lasted at least 6 months?
About 5.5, along the way after I found out she was seeing this man.
And during the time you had that relationship with her, isn't it correct that you courted her in some manner by buying her gifts?
Well, I bought her flowers. I bought her a set of pajamas and a bathroom, pair of earrings.
Would I be correct in, as also as part of a courting type gesture that you also sometimes gave her money?
Never gave her money. Better, I took her grocery shopping on several occasions. She put $1,250 on my bridge card that I got from the state. Pandemic money that accumulated on it.
And it's sometimes during this relationship that you had, you would eat over her house, isn't that correct?
At breakfast every once in a while. Coffee. No dinners to speak of. Every once in a while on holidays, there's a big meal for 10 or 12 guests to show up.
Now, would I be correct that at some point after her marriage to Mr. Larkin, that you began to indicate that you believed that Mrs. Larkin owed you money?
Yes.
Okay. And on the date of July the 3rd of 2023, you actually had an encounter with Mrs. Larkin. Is that correct?
A discussion with her on the elevator.
Isn't it correct that you threatened her at the time with regard to the?
I never threatened that woman in my life. I told her, if this is a threat, I said to her, I'm tired of listening to her con artist lies, and I said, I guess the only way I'm gonna get my $1,550 back, I'm gonna take the court and sue you and let a judge make a decision. Now, is that a threat?
This line is deceptively powerful. On the surface, it sounds lawful, civil, reasonable. I'll sue you. But in context, it carries emotional weight. It's not said in a courtroom. It's said in an elevator, alone, to a married woman, with a complicated history. The defense wants the court to hear this not as a legal plan, but as pressure, repeated confrontations, money demands, emotional entanglement. The subtext is, this wasn't over. It followed her home. And now the legal question becomes subtle. Does repeated confrontation over money without a written agreement become harassment? Does it justify fear? Does it provoke response? From the prosecution's side, this still doesn't justify a gun. From the defense's side, it explains why a husband might explode.
Is that
That's a statement.
That's a statement, okay. Isn't it correct that on occasions that you did say that you would have to do something about this, vaguely?
Legally?
No, just generally, that you would say to her, that you said to her that you were going to have to do something about this if she didn't pay you back your money.
I just explained to you. That takes her to court and sue her.
So my question is, did you ever use the words that I just said?
If you're asking me if I ever threatened this woman, no, I've never threatened this woman. I made a mistake.
Okay, I'm gonna try to reframe my question because I don't believe you're understanding me. Isn't it correct that when you saw her on the elevator, this was not the first time that you had approached her with regard to this money?
No, it's not the first time. It's about the third time in 22 months.
And isn't it correct that on these at least 3 times that you approached her, that on at least one of the occasions you said, if I don't get my money back, I'm gonna do something about this?
No, I never made a mistake. I made you the correct statement. What I said to her.
And would I be correct in stating that you have no written agreement with her with regard to paying back the money?
No, but I've got it all logged on a calendar book of 2020.
So on this day, after you had threatened Miss Larkin, isn't it correct that that's when you?
Beat yourself.
Isn't it correct after you had made these threats to Mrs. Larkin in the elevator, that after that is when you saw Mr. Larkin, correct?
I didn't make any threats to that one.
Isn't it correct that after that encounter that you saw Mr. Larkin?
Went out front, his wife and I went out front door together, got on the elevator on my floor. She needed a shopping cart, unloaded groceries, and her car was parked right there. That's when I got in my car with Paula and left to go to the Hope Center. I was going approximately an hour before I got back. In the meantime.
And would I be correct in stating that when you got back, it was after you saw and had your encounter with Mrs. Larkin in the elevator?
I saw him 1 hour after I had an encounter with her. 6:10 p.m.
Now, when you saw Mr. Larkin, would I be correct in stating that Mr. Larkin used a cane?
What?
That he had a cane to walk with?
Yeah.
Am I correct in stating that Mr. Larkin always uses some sort of assistance or aid, like a cane or a scooter, to get around?
I've seen him use several things.
And would I be correct in also stating that when you saw Mr. Larkin, that he had apparatus for breathing, for his oxygen tank?
All I know is
In the past, would I be correct in saying that you've seen Mr. Larkin with oxygen?
not really. I've seen him use a big tall walker, push cart walker, and a cane. I don't ever remember. I can't particularly say I've noticed him using oxygen. I've got a sign on the door that says oxygen.
So you've seen the sign on his apartment door that states oxygen in use? And would I be correct in stating that your girlfriend lived across the hall from Mrs. Larkin while you were engaging in this sexual relationship? And during that time, there was no sign about oxygen in use on Mrs. Larkin's door. Is that right?
No, there wasn't.
So that was only after Mr. Larkin moved in that sign came up, correct?
Yes, I'd say so.
Now the defense pivots to vulnerability. Cane, walker, oxygen. These aren't details, they're leverage. The implication is clear. This is not a physically dominant man. This is someone with medical limitations. Why does that matter? Because self-defense and threat perception depend on relative power. The defense wants the court to visualize a frail man confronting a mobile one. A husband protecting his home, not hunting prey. But here's the legal friction. Firearms equalize power instantly. A gun erases physical disadvantage. The moment it's drawn, the balance flips. The prosecution will argue that disability does not grant immunity. The defense will argue that disability explains fear, and the judge must weigh both. This is the psychological hinge of the case. Was the defendant acting out of terror or control?
Would I be correct in stating that you do not use any aids to assist you with walking?
Not yet. Almost 82.
Would I also be correct in stating that you do not use oxygen to assist with your breathing?
No, I don't.
Would I be correct in stating that when Mr. Larkins approached you about your encounter with his wife earlier that day, that you were not pleased with his interaction with you?
Why would I be pleased when they were just trying to kill me?
Would I be correct in stating that on prior occasions, when approaching Mrs. Larkin with regard to the money you believe she owes you, that you called her or referred to her as something other than her name?
No, never.
Would I be correct in stating that you actually have, on at least 2 occasions, when asking about the money you believe you're owed, called her an Nigger?
No, I never.
Isn't it correct that you have also referred to Mr. Larkin in that manner?
I did one time, yes. He told me he was gonna beat my motherfucking ass on my, called me up on my phone, told me that was the second time he threatened physical violence.
And isn't it correct that's because you have repeatedly threatened his wife, Mrs. Larkin, regarding this money that you say she owes you?
Objection.
I've never threatened that woman with anything, other than a statement.
Sustained. Sustained. Go ahead.
And would I be correct in stating that when Mr. Larkin spoke to you about your encounter with his wife that day, that when he initially spoke to you, when he spoke to you initially, there was no weapon displayed.
There was what?
There was no weapon displayed when he initially spoke to you.
No, he displayed the weapon right after he got done saying, I told you never talk to my wife again, or I'll blow your motherfucking brains out. He stepped back, jerked his shirt up, pulled it out of his belt, shoved it up underneath my throat for about 5-6 seconds, then put the barrel on my forehead about 5 or 6 seconds.
Isn't it correct that after he said what he said to you, that you actually took steps closer to him?
Why would I do that?
And isn't it correct that the weapon was not displayed until after you had made these steps towards him?
I never made any steps towards that man. He was doing the stepping towards me.
And isn't it correct that at that time, he was the person who needed the assistance with the walking, correct?
How was I to know that? He didn't look like he didn't have any problem walking up there where he walked from the building up to where I was at.
But he did walk with a cane, didn't he?
He had a cane, yeah.
And you'd seen him before, you stated, with a walker.
don't see that man not that often.
My question is, had you,
Apparatus for one day, and the next day you might have a different apparatus.
but you had seen him before using a walker,
Yes,
and you'd seen him before using a scooter.
yes.
And may I have one moment, please?
You may.
Those are all the questions I have for you this time. Thank you.
Sir, you may step down. Thank you.
We call Officer Marquez Gibbs.
Sir, please come forward to be sworn.
Solemnly swear affirm the testimony about to give the truth, the whole truth, and nothing but the truth, so help you God. See, state is still your first and last name.
Marquez Gibbs, Martezgibbs.
You may inquire.
Thank you. Mr. Gibbs, how are you employed?
Ypsilanti Police Department as police officer.
And were you working on July 3rd, 2023?
Yes.
Did you get dispatched out to 401 West Michigan to investigate a felonious assault?
Yes.
And when you got there, did you ultimately speak with someone named Bruce Larkins?
Yes.
And is that person in the courtroom today?
Yes.
He's where is he?
He's right over there.
All right, thank you. And at some point, were you able to recover a firearm from Mr. Larkins' apartment?
Yes.
And you had an opportunity before the hearing today to look at people's exhibit number 1, that
Yes.
photo. Is that the firearm that was recovered?
Yes.
And did you inspect that firearm to see if it's a working, legitimate firearm?
Yes.
Was it loaded when you
Yes.
found it? Excuse me. When you found it, was it loaded?
Yes.
3 words, and the entire case tightens. A loaded firearm changes everything. This wasn't a symbolic gesture. This wasn't a bluff. This was a live weapon capable of killing in a fraction of a second. In criminal law, that converts a confrontation into a lethal event. The officer's testimony also removes doubt. The gun existed. It worked. It was recovered. This isn't a story problem. It's an evidence problem. Defense gains 1 point. The defendant cooperated. He disclosed. He didn't hide the weapon. That helps character. But it doesn't erase the act. Legally, probable cause is now solid. A credible victim. Identified defendant. Recovered loaded firearm. Officer confirmation. At this stage, the court isn't deciding guilt. It's deciding whether the case deserves a trial. And with these facts, that bar is low. Ask yourself, if a gun is loaded, does intent even matter anymore? Or does the danger itself become the crime? This is where the law stops caring about emotion and starts caring about risk.
And thank you. No other questions.
All right. Cross-examination.
So Gibbs, you indicated that you found the firearm. Let me back up. Officer Gibbs, approximately what time did you arrive at Mr. and Mrs. Larkin's apartment?
Couldn't tell you. I can't recall. I have to look at the incident.
By chance, would you have your report with you to refresh your recollection?
Yeah. I'll come around.
I can, Your Honor, may I have a moment to?
You may.
After looking at your report, is your recollection refreshed?
Yes.
So approximately what time did you arrive at Mr. Larkin's apartment? And when you arrived at Mr. Larkin's apartment, you indicated that you initially had an opportunity to speak to him. Is that correct?
Yes.
And he did in fact tell you that. I'll rephrase that.
Thank you.
Isn't it correct that based on your conversation with him, you were able to find a firearm in his apartment, correct?
Yes.
And at all times, Mr. Larkin was cooperative with you, is that right?
No.
Would I be correct in saying that Mr. Larkin was upset about the situation that occurred with he and his wife? Yes. But he did not lie to you about having a firearm, isn't that correct?
No.
Defense is building the responsible gun owner narrative. They want the court to see cooperation as character evidence. He admitted possession. He disclosed the permit. He didn't resist the investigation, and the police found the weapon without a chase, without a standoff, without deception. That matters emotionally. People instinctively trust the person who doesn't hide. But legally, cooperation doesn't cancel an assault. It just reduces the dangerous criminal vibe and replaces it with otherwise lawful person who snapped. This is also about intent. The defense wants the judge and future jury to believe he wasn't out committing crimes. He was dealing with a personal crisis. Prosecution response will be simple. Lawful ownership does not equal lawful use. A carry permit is not permission to intimidate. If the gun was used as a threat, the permit becomes irrelevant to guilt. Engagement question. Does honesty after the fact make you see the incident differently, or is the act itself all that matters?
And isn't it correct that he even told you he had a CPL?
Indeed, yes.
And you were able to confirm that he has a CPL?
Yes.
So he is licensed to carry, and you were able to find the weapon without any challenges. Okay. When you arrived, would I also be correct in stating that you were able to observe that Mr. Larkin had on
What's the name? Yes, and a walking cane.
thank you. So you were able to see that he was utilizing or had recently utilized having to have oxygen.
Yes.
And would I be correct in that you also were able to see that he needed aids to assist him with walking?
Yes.
So you saw his cane, is that correct? And did you see his walker?
No, didn't see a walker.
Did you see a motorized scooter?
No, didn't see that. Once we were in the hallway though, so.
And when you arrived at 6:14 p.m., would I be correct in stating there was not a firearm on Mr. Larkin's person?
Correct.
And that you at no time saw a firearm on Mr. Larkin's person?
Correct.
But you were able to see that he had, as a person licensed to carry, that he had the appropriate equipment to carry if he chose to, correct?
Yes.
This is the defense trying to thread a needle. They want to normalize lawful carry without admitting unlawful brandishing. He has the equipment. He's licensed. He's compliant. It's an attempt to frame the firearm as part of ordinary life, not criminal intent. But there's risk here. To many viewers, appropriate equipment to carry sounds like planning. It sounds like readiness. It sounds like the ability to escalate quickly. A prosecutor can flip that. If you are trained, licensed, and equipped, you also know the rules. You know you can't threaten people. You know drawing a gun is the nuclear option. That's the tension. Training cuts both ways. It can show responsibility, or it can show awareness of wrongdoing. Engagement question: if someone is licensed and trained, should we hold them to a higher standard in heated confrontations?
Your Honor, may I have one moment, please?
You may.
Right, thank you. Those are my questions. Thank you, Your Honor.
Any redirect?
No.
All right, thank you. You may step down. Any further witnesses for the people?
No.
Any witnesses for the defense?
No.
Move to bind over.
Response?
Your Honor, we object to the bind over.
Based upon the, don't need argument, based upon the testimony in this case, the court would find that the people have shown by probable cause that an offense was committed and that the by probable cause that the defendant committed the offense. Therefore, the defendant is bound to risk trial.
Judge Simpson's ruling is decisive but narrow. He's not saying guilty. He's saying the prosecution cleared the threshold to proceed, and given the evidence, that's expected. Here's why. The witness described a direct, immediate threat with a firearm. The defendant was identified. The firearm was recovered and confirmed operational and loaded. That combination typically satisfies probable cause for assault-related charges. The defense's best arguments: relationship history, Money dispute, harassment context, disability may become powerful at trial because trial is where reasonable doubt matters. But at this stage, the judge is not weighing every nuance. He's asking, does this deserve a jury? This ruling also signals something important. The judge believes the prosecution's evidence is coherent enough that a reasonable jury could convict if they believe it. That's the practical meaning. Engagement question. Based on what you've heard so far, do you think this looks like a clear-cut gun threat or a messy personal conflict that got out of hand?
On this count. Ms. King.
Yeah, we acknowledge receipt of the information that is legal on the record, and at this time, my client wishes to stand.
Defendant. Waiving formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
September 12th at 1:30 p.m. with Judge Conley.
September 12th, 2023, 1:30 before Judge Conley.
And that's the procedural landing. Bound over, not guilty plea entered, and the case is officially moving forward toward trial preparation. The big takeaway is this. Judge Simpson believes there is enough evidence to justify a full trial, which means this dispute is no longer just personal. It's criminally actionable in the eyes of the court. The prosecution's core case is straightforward. A witness claims he had a loaded gun shoved under his throat and pressed to his forehead while threats were repeated. The firearm was later recovered and confirmed loaded and functional. Identity was established in court. That's a strong probable cause package. The defense's counter-narrative is also clear. This wasn't random. There's a complicated relationship history involving the defendant's wife, financial disputes, repeated confrontations, and a defendant with mobility and oxygen issues, suggesting fear, provocation, or at least context that could change how intent is interpreted. At trial, the fight won't be about whether a gun exists. It'll be about credibility, escalation, and whether the story leaves reasonable doubt. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.